Hello, welcome to a new session. In this video we going to learn Indian Contract Act from Business Law and Ethics.
Free consent. Mutual consent or consensus ad idem, that is meeting of mind consent, is free when it is not caused by coercion, undue influence, fraud, misrepresentation or mistake. Section 15. Coercion. Committing or threatening to commit. Unlawful detaining or threatening to detain. Even a threat to third party also included. Mere threat to prosecute does not amount to coercion. Actually committing an offense forbidden by IPC. Applicability of IPC is not relevant at the time when coercion is employed, or at the place where coercion is employed. Coercion may proceed from a party to the contract, or stranger to contract. Coercion may be directed against a party to the contract, or stranger to contract. Some examples. 1. X threatens to kill Y if he does not agree to sell his car to X for 10,000 Indian rupees. Fearing death, Y enters into an agreement with X for the sale of his car for 10,000 Indian rupees only. 2. A tells his wife that he would commit suicide if she did not transfer her personal assets to him. She does so. Under this threat, can the wife avoid the contract? And the answer is yes. For more details refer case study Chiksam Amaraja vs Sesh Emma. Next topic. Section 16. Undue influence. A dominant position, i.e. one of the parties dominates will of the other. The use of such position is to obtain an unfair advantage. The dominant party obtains an unfair advantage by way of entering into a contact. Undue influence was employed or not employed. Its burden of proof. 1. Unconscionable transactions. The burden of proof is on the dominant party. The dominant party has to prove that undue influence was not employed. 2. Any other transaction. The burden of proof is on the weaker party. The weaker party has to prove that undue influence was employed. Example. As son has forged B's name to a promissory note. B, under threat of prosecuting A's son, obtains a bond from A for the amount of the forged note. If B sues on this bond, the court may set the bond aside. Refer case laws. Kali Baksh vs Ram Gopal. House vs Bishop. Kirparam vs Sami Uddin ad. Con. Relationship, where undue influence arise. Parent and child. Trustee and beneficiary. Guardian and ward. Master and servant. Religious guru and disciple. Income tax officer in relation to an assessee. A magistrate or police officer in relation to an accused person. Doctor and patient. Financier and financee. Solicitor and client. Relationship, where undue influence does not arise. Landlord and tenant. Creditor and debtor. Husband and wife. Exception. Pardanishan woman, seclusion or being away from the people. Next point we going to learn. Fraud. It must be proved that fraud was committed by a party to the contract, or anyone with the connivance of a party to the contract. The party has made a representation of a fact, an opinion, a statement of expression, or a statement of intention does not constitute a fraud. Essentials of fraud. By a party to the contract. The party makes a representation. The representation is false. The misrepresentation was made innocently. The misrepresentation was not made with a view to deceive the other party. The other party has actually acted. Some examples for better understanding. 1. A fraudulently informs B that his house is free from encumbrances. B hereupon buys the house. The house is subject to a mortgage. B may avoid the contract and get back his money. 2. A man, by the name of Sham, called at jeweler's shop and chose a costly ring. He tendered in payment a check, which he signed in the name of credit. He took the ring and pledged it to Bholanath, who had no notice of the fraud. Can the jeweler recover the ring from Bholanath? And the answer is no. 3. A woman fraudulently represented to a firm of jewelers that she was the wife of a certain baron and thus obtained 2 pearl necklaces on credit on some pretext with a view to buying them. She sold those necklaces to X, a third person. Can the jewelers recover the necklace from X? And the answer is yes. 4. A sells, by auction, to B, a horse which A knows to be unsound. A says nothing to B about the horse's unsoundness. This is not fraud in A. Next is misrepresentation conditions. There was a representation or assertion. Such assertion induced the party to enter into the contract. The assertion related to a matter of fact, not of law. It was not a mere opinion. It was made with an honest belief in its truth. Here party can only avoid contract and cannot claim damages. Damages for innocent misrepresentation. In case of company's prospectus issued to public. Breach of warranty of authority by an agent. Negligent representation by person having confidential relation. Types. 1. Unwarranted statements. When a person positively asserts, makes an absolute and explicit statements of facts, that fact is true, though he has no reliable source to form this opinion but he believe it to be true. This is one type of misrepresentation. 2. Breach of duty. Any breach of duty which brings advantages to the person committing it by misleading the other to his prejudice is a misrepresentation. Willful misrepresentation or fraud, Section 17. False representation or assertion of fact. Made with intention to induce the other. The statement made either with the knowledge that it was false or without belief in its truth. The party defrauded can avoid the contract and also claim damages. Contracts uberami fide. A contracts having a special duty to act with the utmost good faith. For example, contract of insurance of all kinds. Company prospectus. Contract for the sale of land. Contracts of family arrangements. The representation is false, that is misrepresentation. The misrepresentation was made willfully. The misrepresentation was made with a view to deceive the other party. The other party is actually deceived. The other party has suffered a loss. So when is a representation considered as false? Where the person makes a representation of a fact knowing that such fact is not true. Where the person conceals a fact even though he has knowledge of such a fact. Where a person makes a promise without any intention of performing it. Any act omission declared by law as fraud also amounts to fraud. Any other act fitted to deceive also amounts to fraud. Example. Mr. A, by a misrepresentation, leads Mr. B erroneously to believe that 500 mons of indigo are made annually at S factory. Mr. B examines the accounts of the factory, which show that only 400 mons of indigo have been made. After this Mr. B buys the factory. The contract is not voidable on account of Mr. A's misrepresentation. Silence. General rule. Mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that, regard being had to them, it is the duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. However, in the following 2 cases silence amounts to fraud, where there is change in circumstances. When there is half-truth. Exceptions. Where the parties stand in fiduciary relationship. When silence is equivalent to speech. Partial disclosure of truth which deceives the other party is a fraud. Next is Section 20 and 22. Mistake. If mistake of essential fact, the agreement will be void. Mistake of fact and not of law, because mistake of law no excuse. Mistake must be mutual or bilateral. Miscalculation or error of judgment will not be considered as mistake. Mutual or common mistake as to subject matter. Mistake as to existence of the subject matter. Mistake as to identity of the subject matter. Mistake as to quantity of the subject matter. Mistake as to quality of the subject matter or promise. Bilateral mistake. The agreement is void if the mistake relates to a fact. Such fact is material to the agreement, and both the parties are at mistake. Bilateral mistake may be mistake as to the subject matter. Mistake as to the possibility of performance. Mistake as to subject matter covers following cases. Mistake as to existence of subject matter, that is mutual mistake. Mistake as to identity of subject matter when both parties have different subject matter of contract in their mind. Mistake as to the quality of the subject matter. Mistake as to title of subject matter. Mistake as to price of the subject matter. Mistake as to possibility of performance of contract. Unilateral mistake. The contract is neither void nor voidable. Unilateral mistake as to nature of the contract. Person who signs an instrument is bound by its terms even if he has not read it except in case of the blindness, illiteracy, or senility. A trick or fraudulent misrepresentation as to the nature of the document. Unilateral mistake as to the identity of the person contracted with. Legality of object and consideration. Section 23. Unlawful object or consideration. Meaning and effects. Circumstances in which object or consideration is unlawful. An agreement to do something forbidden by law. An agreement is unlawful if it involves doing of an act which is forbidden by any law for the time being in force. Next. Defeating the provisions of any law. An agreement is unlawful if it is of such a nature that if permitted, it would defeat the provisions of any law, even though it is not directly prohibited by any law. Next. Fraudulent. An agreement is unlawful if it is made to make a fraud on any person. Next. Involves injury to any person or his property. An agreement is unlawful if it is made for the purpose of causing injury to any other person, or property of another person. Next. Immoral or opposed to public policy. An agreement is unlawful if the court regards that object or consideration of such agreement is immoral, or opposed to public policy. Next. Legal effect. Every agreement of which the object or consideration is unlawful is void. When is object or consideration said to be against public policy? Agreement for trading with enemy. Agreement interfering with personal liberty. Agreement interference with parental duties. Agreement interfering with marital duties. Agreement interfering with course of justice. Agreement for improper promotion of litigation. Agreement for stifling prosecution. Maintenance agreement. Champerty agreement. Agreement to do an act against the duty of a person. Marriage brokerage agreement. Agreement not to bid. Agreement to create monopolies or to eliminate or reduce competition. Agreement for sale of public offices and titles. Maintenance and champerty agreement. Meaning of maintenance agreement. A party agrees to provide assistance, financial or otherwise, to another party to institute or defend a suit. The person providing such assistance has no interest in such suit. The party who receives such assistance agrees to pay something in return to the person who provides such assistance. Legal effect of maintenance agreement. The maintenance agreement is valid if it is bona fide and the payment the person providing such assistance is reasonable. Meaning of champerty agreement. A party agrees to provide assistance, financial or otherwise, to another party to institute or defend a suit. The person providing such assistance has no interest in such suit. The party who receives such assistance agrees to share the proceeds from the suit received by him in return to the person who provides such assistance. Legal effect of Champerty agreement. The Champerty agreement is valid if it is bona fide and the share of proceeds paid to the person providing such assistance is reasonable. Section 25. Agreements unlawful in part. An agreement containing legal and illegal parts. Whether unlawful part can be separated from unlawful part. If yes, lawful part can be enforced, or unlawful part cannot be enforced. If no, the whole agreement is void. A reciprocal agreement containing legal and illegal parts. A reciprocal agreement containing legal and illegal parts. The reciprocal promise to do legal things can be enforced. Illegal things cannot be enforced. An agreement containing legal and illegal parts. The alternate promise to do legal things can be enforced. Illegal things cannot be enforced.
Section 30. Wagering agreements. An agreement between two persons under which money or monies worth is payable, by one person to another on the happening or non-happening of a future uncertain event is called a wagering agreement. Effects of wagering agreements. The agreement is void. The agreement is illegal in the states of Maharashtra and Gujarat. No suit can be filed to recover the amount won on any wager. Agreements not held as wagers. Agreement to pay prize money not exceeding Rs 1,000. An agreement to pay a prize exceeding Rs 500 to the winner of a horse race is not a wager. Section 31. Contingent contracts. A contingent contract is a contract to do or not to do something. If some event, collateral to such contract, does or does not happen. Essentials features of a contingent contract. It is a contract to do or not to do something. This contract is dependent on happening or non-happening of an event. Such an event is a collateral event, i.e., it is collateral to the contract. That is, the event must not depend upon the mere will of a party. The event is uncertain. When contingent contract is enforced. When such event has happened. When the happening of such event becomes impossible. When such event has happened within the specified time. When the happening of such event becomes impossible before the expiry of specified time. When such event has not happened within the specified time. When such person acts in the manner as desired in the contract. Now let's see when does it become void in contingent contract. When the happening of such event becomes impossible. When such event has happened. When the happening of such event becomes impossible before the expiry of specified time. When such event has not happened within the specified time. When such event has happened within the specified time. When such person does anything which makes the desired future conduct of such person impossible, or dependent upon certain contingency. Lastly, impossible events. Such an agreement cannot be enforced since it is void. Whether the impossibility of the event was known to the parties or not is immaterial. Void agreements. A void contract is one which is destitute, which is great need of legal effects become void. An illegal contract too has no legal effect and also void. Any benefit received in void contract has to be restored. Consequences of illegal or void agreements. Illegal agreement is entirely void. No action can be brought by a party to an illegal agreement. Money paid or property transferred here cannot be recovered. If contract consist of two part, that is legal and illegal, and if separable, then legal part become valid and other void. If not separable, entire contract become void. Any future contract based on a legal contract also become void. I have listed out all the void agreements in the slide for your reference. Take a look. Section 26. Agreements in restraint of marriage. Every agreement in restraint of the marriage of any person is void. Section 27. Agreements in restraint of trade. Every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is void. To that extent. Burden of proof. Party supporting the contract must show that the restraint is reasonably necessary to protect his interests. Party challenging the contract must show that the restraint is injurious to the public. Exceptions to Sector 27. Sale of goodwill. Such restriction must relate to a similar business. Such restriction must be within specified local limits. Such restriction must be for the time so long as the buyer or any person deriving title to the goodwill from him carries on a like business in the specified local limits. Such specified local limits should be reasonable having regard to the nature of the business. Next. Restriction on existing partner. An agreement by a partner not to carry on any business other than that of the firm is valid. Next. Restrictions on outgoing partner. An agreement may provide that an outgoing partner will not carry on a similar business after dissolution of the firm. Such restriction must be within specified local limits or within a specified period. The restriction should be reasonable having regard to the nature of the business. Next. Restrictions on partners. Upon or in anticipation of the dissolution of the firm, an agreement may provide that some or all of the partners will not carry on a similar business. Such restriction must be within specified local limits or within a specified period. The restriction should be reasonable having regard to the nature of the business. Next. Restriction in case of sale of goodwill of a firm. At the time of sale of goodwill of the firm, a partner may agree that he will not carry on a similar business. Such restriction must be within specified local limits or within a specified period. The restriction should be reasonable having regard to the nature of business. Section 28. Agreements in restraint of legal proceedings. An agreement by which any party is restricted absolutely from enforcing his legal rights under any contract is void. An agreement which limits the time within which an action may be brought is void. Exceptions to Section 28. An agreement is not void merely because it provides that any dispute arising between two or more persons shall be referred to arbitration. An agreement is not void merely because it provides that any dispute that has arisen between two or more persons shall be referred to arbitration. Quasi-contracts. It means a contract which lacks one or more of the essentials of a contract. Quasi-contracts are declared by law as valid contracts on the basis of principles of equity, that is, no person shall be allowed to enrich himself at the expense of another. The legal obligations of parties remain same in case of a quasi-contracts. Also, i.e., the parties will have same obligations and rights as if such quasi-contract fulfills all the essentials of a contract. Section 68. Supply of necessaries to persons incompetent to contract. A person who is incompetent to contract is made liable under Section 68. Conditions of Section 68. The liability of an incompetent person arises if necessities are supplied to such person that is incompetent person, or any other person who is dependent on such incompetent person. Liability of incompetent person. The person who supplies necessities to the incompetent person is entitled to be reimbursed from the property of such incompetent person. However, the incompetent person is not personally liable. Necessities means necessaries suitable to the conditions in life of the person to whom such necessities are supplied. Example: Mr. A supplied rice and wheat to the wife and children of Mr. B, who is a lunatic. Mr. B has assets worth 1 lakh of rupees. On non-payment, Mr. A can proceed against the assets of Mr. B. Section 69 Payment by a person who is interested in a transaction. Reimbursement of a person paying money due by another in payment of which he is interested. Conditions of Section 69. One person is legally bound to make a payment. Some other person makes such payment. The person making such payment is not legally bound to make such payment. The person making such payment is interested in paying such amount. Legal effect of Section 69. If all the conditions of Section 69 are satisfied, the person who is interested in paying such amount shall be entitled to recover the payment made by him. Refer case law. Exol vs. Partridge. Mr. A left his carriage on Mr. B's premises. Mr. B's landlord seized the carriage as distress for rent. Mr. A paid the rent to obtain the release of his carriage. Mr. A can recover the amount from Mr. B. Section 70. Obligation of person enjoying benefit of non-gratuitous act. Conditions of Section 70. A person has lawfully done something for another person, or delivered something to another person. Such person must have acted voluntarily and non-gratuitously. The other person has enjoyed the benefit of the act done for him, or the thing delivered to him. Legal effect of Section 70. If the conditions of Sector 70 are satisfied, there will be a quasi-contract between the parties. Consequently, the party who has done something or delivered a thing shall be entitled to recover its value from the person who obtained the benefit of the same. Example: Mr. A tradesman, sends some goods ordered by Mr. B. Mr. A's servant delivers the goods by mistake at Mr. C's house. Mr. C uses the goods. Mr. A can recover the price of the goods from Mr. C, not from Mr. B. Section 71. Finder of goods. A finder of goods has same rights and duties as that of a bailee. Example: Mr. X finds the lost dog of Mr. Y and takes into his custody. Here, Mr. X has the same responsibility as bailee. Section 72. Money paid under a mistake or coercion. Conditions of Section 72. A person has paid money to another person, or delivered something to another person. Such person must have acted under a mistake, or under coercion. Legal effect of Section 72. If the above conditions are satisfied, there will be a quasi-contract between the parties. Consequently, the party who has paid money or delivered a thing shall be entitled to recover its value from the person who obtained the benefit of the same. Example: Mr. A and Mr. B jointly owe 200 to Mr. C. Mr. A pays the amount to Mr. C. Mr. B, not knowing this fact, pays Rs.100 over again to Mr. C. Mr. C is bound to repay the amount to Mr. B.
Performance of a contract. Every contract creates certain obligations on each of the parties involved in it. When both the parties to the contract fulfill their obligation towards each other, the contract is said to be performed. When both the parties to the contract have performed their obligation, the contract is said to be discharged by performance. Example: Mr. A desires Mr. B, who owes him Rs.100, to send him a note for Rs.100 by post. The debt is discharged, promise is fulfilled, as soon as Mr. B puts into the post a letter containing the note duly addressed to Mr. A. Section 37 and Section 38. Obligations of parties to contracts. Actual performance. Promisor makes an offer of performance to the promisee. The offer has been accepted by the promisee. as per the terms and conditions. Prescribed manner. One party performs and other party duty is to perform. Example. Jin buys a house from J Hope for Rs. 5 lakhs. Jin pays the price and J Hope delivers the papers of the house. Next. Offer to performance. Tender performance. Attempted performance. Promisor makes an offer of performance to the promisee. The offer has not been accepted by the promisee. When the performance becomes due, the promisor does not lose his right. Offers to perform his obligation but the promisee refuses to accept the performance. Example. Mr. Jimin promises certain goods to Mr. Namjoon. Mr. Jimin takes the goods to the appointed place during business hours. But Mr. Namjoon refuses to take the delivery of goods. Types of tenders and their effects. 1. Tender of goods and services. Goods or services need not be offered again if the promisor is discharged. Not required to offer again. Not responsible for non-performance. Is entitled to sue the other party. 2. Tender of money. The debtor remains liable to pay the debt. The debtor is discharged from liability for payment of interest from the date of tender. Section 38. Conditions or essentials for a valid tender. The tender must be unconditional. The tender must be for the whole obligation. The tender must be given at a proper time. The tender must be given at a proper place. The tender must give a reasonable opportunity of inspection. The party giving the tender must be willing to perform his obligation. The tender must be made to the proper person. The tender must be made for the exact amount of money. Persons liable for, and entitled to performance. 1. Persons liable for performance promisor. Persons entitled to performance promisee. Example. Mr. X promises to paint a picture for Mr. Y. He will have to do himself as it involves his personal skill. Cannot be enforced either by Mr. X's representatives. 2. Persons liable for performance agent of promisor. Persons entitled to performance agent of promise. 3. Persons liable for performance in of the several joint promisors. Persons entitled to performance joint promises. Any one promisor may be compelled to pay and the loss may be shared by the others in the case of default. A legal representative is liable only to the extent of property of the deceased received by him. Example. Mr. A, Mr. B and Mr. C jointly promise to pay Mr. D Rs. 3,000. Mr. A and Mr. B are untraceable. Mr. D shall compel Mr. C to pay in full. Mr. A, Mr. B and Mr. C jointly promise to pay Mr. D the sum of Rs. 3,000. Mr. C is compelled to pay the whole. Mr. A is insolvent, but his assets are sufficient to pay 1/2 of his debts. Mr. C is entitled to receive Rs. 500 from Mr. A's estate and 1,250 from Mr. B. Mr. F, B, and G jointly borrowed Rs. 5,00,000 from Mr. W. The whole amount was repaid to Mr. W by Mr. B. Decide whether. Solution. Mr. B can recover the contribution from Mr. F and Mr. G because Mr. F, B, and G are joint promisors. If F has died, legal representatives of F are liable to pay the contribution to B. However, a legal representative is liable only to the extent of property of the deceased received by him. G is insolvent. B also can recover the contribution from G's assets. 4. Persons liable for performance. Legal representative of a promisor. Persons entitled to performance. Legal representative of a promisee. Example. Mr. A promises to deliver goods to Mr. B on a certain day on payment of Rs. 1,000. Mr. A dies before that day. Mr. A's representatives are bound to deliver the goods to Mr. B, and Mr. B is bound to pay Rs. 1,000 to Mr. A's representatives. 5. Third parties. Stranger. If the performance is accepted by the promisee, authorization or ratification is immaterial. Example. Mr. A received certain goods from Mr. B promising to pay Rs. 1,00,000. Later on, Mr. A expressed his inability to pay. Mr. C, who is known to Mr. A, paid Rs. 60,000 on behalf of Mr. A. However, Mr. A was not aware of this payment. Here, Mr. B can sue only for the remaining amount Rs. 40,000. Performance of joint promise. All the joint promisors are jointly and severally liable. However, the contract between the joint promisors may provide otherwise. A joint promisor may claim contribution from other joint promisors, if he is compelled to perform the whole promise. A joint promisor may claim contribution from other joint promisors, if any other joint promisor makes a default in performance of his promise. Where one of the joint promisors is released, other joint promisors shall continue to be liable. Appropriation of payments. 1. Application of payment where debt to be discharged is indicated. A debtor owes several distinct debts to the creditor. The debtor makes a payment to the creditor. The debtor intimates the creditor that the payment made is to be applied to the discharge of some particular debt. The creditor has no option but to apply such payment for the discharge of such particular debt. 2. Application of payment where debt to be discharged is not indicated. A debtor owes several distinct debts to the creditor. The debtor makes a payment to the creditor. The debtor does not indicate the debt for which the payment is to be applied. The creditor has the discretion to apply such payment for any lawful debt which is due to him from the debtor. 3. Application of payment where none of the parties makes the appropriation. A debtor owes several distinct debts to the creditor. The debtor makes a payment to the creditor. The debtor does not indicate the debt for which the payment is to be applied. The creditor accepts such payment but does not apply such payment for any lawful debt which is due to him from the debtor. The payment shall be applied in discharge of the debts in order of time. Reciprocal promises. Section 2F. Promises that form the consideration or part of the consideration for each other are called reciprocal promises. Example. Mr. A and Mr. B contract that Mr. A shall build a house for Mr. B at a fixed price. Mr. A's promise to build the house must be performed before Mr. B's promise to pay for it. Next. Simultaneous promise. The promisor is not bound to perform, unless the promisee is ready and willing to perform his promise. Next. Alternative promise. Contracts with legal and illegal object. Examples. Mr. A and B agree that Mr. A shall pay Mr. B Rs. 1,000 rupees for which Mr. B shall afterwards deliver to Mr. A either rice or smuggled opium. Valid contract to deliver rice, and a void agreement as to the opium. Mr. A and B agree that Mr. A shall sell to Mr. B a house for Rs. 10,000, but that, if Mr. B uses it as a gambling house, he shall pay Mr. A Rs. 5,000 for it. The first set of promises is a contract, but the second set is a void agreement. Discharge of a contract. Meaning of discharge of a contract. Discharge of contract means termination of contractual relations between the parties to a contract. When the rights and obligations created by a contract come to an end, the contract is said to be discharged or terminated. Modes of discharge of a contract. 1. Discharge by performance. 2. Discharge by impossibility of performance. 3. Discharge by mutual agreement. 4. Discharge by lapse of time. 5. Discharge by operation of law. 6. Discharge by breach of contract. Next. Discharge by performance. Performance is the usual mode of discharge of a contract. Performance may be classified into two types: actual performance, attempted performance, or tender performance or offer of performance. 1. Actual performance. When both the parties perform their respective obligations in accordance with the terms of the contract is discharge. 2. Attempted performance or tender performance. Where a valid tender is not accepted by the other party, the promisor is discharged. That is, when promisor offers to perform his obligation, but the promisee refuses to accept the performance, it amounts to attempted performance. A valid tender of performance is equivalent to performance. Next, discharge by impossibility of performance. Impossibility of performance results in the discharge of the contract. An agreement which is impossible is void, because law does not compel to do impossible things to do. Supervening impossibility. Meaning, no impossibility existed at the time of making of the contract. The impossibility arises subsequently to the formation of the contract. The impossibility arises because of change in circumstances beyond the contemplation of parties, or change in law. The impossibility is of such a nature that it makes the performance of a contract impossible or illegal. If particular state of things, which forms the basis of a contract, ceases to exist or occur, the contract is discharged. Let's look into a case study for better understanding. Krell vs. Henry. X hired a room from Y for viewing the coronation process of Kind Edward. The procession was cancelled because of Kind's illness. Since the ultimate and only purpose of the contract was defeated, the contract was discharged. Partial failure of objects or partial impossibility does not discharge a contract. Next case law. H.B. Steamboat Company versus Hulton. X agreed to hire a boat from Y for the purpose of viewing the naval review on the eve of coronation of Kind and for sailing around the fleet. Due to King's illness, the naval review was cancelled, but the fleet was assembled. X used the boat for sailing around the fleet. Although the primary purpose of the contract was defeated, the secondary purpose was fulfilled and therefore, the contract was not discharged by supervening impossibility. Effects of supervening impossibility. The contract becomes void. All the parties are discharged from their respective obligations. Restitution is allowed. Next. Discharge by mutual agreement. 1. Novation. Novation means substitution of a new contract in place of the original contract. In other words, new contract between the same parties or new terms. Applicable before the expiry of the original performance and substitution in present contract only. The new contract may be between the same parties, or between different parties. A new contract is entered into in consideration of discharge of the old contract. In other words, the consideration for the new contract is the discharge of the original contract. I hope made it clear to you all. Example. Mr. X has to pay 1000 Indian rupees to Mr. Y, while Mr. Y has to pay the same amount to Mr. Z. Under which Mr. X will pay to Mr. Z. This is a new contract between Mr. X and Mr. Z, terminating the old one between Mr. X and Mr. Y. 2. Alteration. Alteration means a change in one or more of the terms of a contract, with mutual consent of parties. That is change in terms. Keep in mind that reviving of the original contract is possible. An alteration discharges the original contract and creates a new contract between the parties. However, the parties to the new contract remain the same. Example. Mr. X agreed to supply to Mr. Y 50 bags of rice at the rate of 100 Indian rupees per bag. The delivery was to be made in 5 equal installments. The first supply was to commence from June 1st. Subsequently, Mr. X and Mr. Y entered into an agreement that the deliver would be made in 2 equal installments and the price would be 105 Indian rupees per bag, change in Terms. 3. Remission. Remission means acceptance of a lesser consideration than agreed to in the contract. In simple words, lesser fulfillment or acceptance of less money, while the sum is due. A promise may dispense with, wholly or in part, the performance of a promise made to him, or extend the time for performance due by the promisor, or accept a lesser sum instead of the sum due under the contract, or accept any other consideration than agreed to in the contract. No consideration is necessary for remission. Example: Mr. X owed 5,000 Indian rupees to Mr. Y, Mr. X paid 2,000 Indian rupees to Mr. Y, and Mr. Y accepted it in full satisfaction. In this case, Mr. X is discharged from his liability of 5,000 Indian rupees. 4. Rescission. It means cancellation of a contract by one or all the parties to the contract. That is, cancellation of terms. A party whose consent was not free may avoid the contract. A party to the contract may rescind a contract if breach of contract is made by the other party to the contract. All the parties may mutually agree to bring the contract to an end. Example: Case law. Long vs. Lloyd. S induced R to buy his motorcycle, saying that it was in a very good condition. After taking the motorcycle, R complained that there were many defects in the motorcycle. S proposed to get it. 5. Waiver. Waiver means intentional relinquishment of a right under a contract. That is, abandonment of the rights. Withdrawal by giving reasonable notice is possible. Example: Mr. X promised to paint a picture for Mr. Y. Afterwards, Mr. Y forbade him to do so. In this case, Mr. Y has waived his right to claim the performance, and thus, Mr. X is no longer liable to perform the promise. 6. Merger. Conversion of an inferior right into a superior right is called as merger. The effect of conversion is that the contract under which inferior right is created is discharged. Next. Discharge by lapse of time. Where the time of performance by a party is due but the party fails to perform within the time specified, the contract is discharged by non-performance. In simple words, every contract must be performed within a fixed or reasonable period of time. Lapse of time discharges the contract. The Indian Limitation Act has prescribed the period within which the existing rights can be enforced in court of law. Next. Discharge by operation of law. Death. Contracts involving personal skill, knowledge, or ability of the deceased party are discharged automatically. Example: Mr. X, an expert, agreed with Mr. Y to translate some part of book from French to English, died before the translation work started. The contract involves personal qualification of promisor Mr. X. Insolvency. The insolvent is discharged from liability on all contracts entered into up to the date of insolvency. Unauthorized material alteration. An alteration which changes the substance, that is, legal effect or basic character of a contract, is called as material alteration. Example: Mr. X contracted to sell his plot of 500 square yards to Mr. Y for 10 Indian rupees lakhs. The sale deed was executed, which was in possession of Mr. A. Before the registration of the sale deed, Mr. X altered the deed and made it a deed for the sale of 300 square yards plot for 10 Indian rupees lakh. Mr. Y is not bound to purchase the plot. Merger of rights. If the rights and liabilities arising under a contract vest in the same person, the contract is discharged. Discharge by breach of contract. Failure of a party to perform his part of contract is called as breach. Consequences of breach. The other party is relieved from performing its part of obligation. It gets a right to proceed against the party at fault. Next topic. Kinds of breach. Actual breach. 1. Time when breach takes place. On the due date of performance. During performance. 2. Manner in which actual breach may take place. Where a party fails to perform. Where a party refuses to perform. Where a party acts in such a manner that it becomes impossible for him to perform. Next. Anticipatory breach. Where a party declares his intention of not performing the contract before the performance of contract is due. Modes of anticipatory breach. Express repudiation. Where a party refuses to perform his obligation before the performance has become due. Party disables himself. Where a party acts in such a manner that it is impossible for him to perform, that is, the party has disabled himself from performance that he had promised. Remedies for breach of a contract. Following remedies are available in case of breach of a contract. 1. Rescission. 2. Suit for damages. 3. 4. Suit for injunction. 5. Suit for quantum merit. 6. Suit for specific performance. Rescission. Rescission means a right available to an aggrieved party to terminate a contract. Effects of rescission. The aggrieved party is not required to perform his part of obligation. The aggrieved party can claim compensation for any loss caused to him. Suit for damages. Monetary compensation allowed for loss suffered by the aggrieved party due to breach of a contract. Object of awarding damages. Not to punish the party at fault. To make good the financial loss. Breach of contract. Next topic is kinds of damages. Ordinary damages. These damages are awarded for such loss suffered by a party which is a proximate consequence of breach. Damages are not awarded if they have resulted because of an indirect consequence. Next point. Special damages. Special damages are awarded to cover such loss which does not arise naturally, but was in the contemplation of both the parties at the time when the contract was made. These damages can be recovered only if the special circumstances which would result in a special loss in case of breach of a contract are communicated to the other party. Next point. Exemplary or punitive or vindictive damages. These damages are awarded only in the following two cases. 1. Breach of a contract to marry. The damages shall be calculated on the basis of mental injury sustained by the aggrieved party. 2. Unjustified dishonor of a check. The damages shall be calculated on the basis lower the amount of check, greater will be the damages. Next point. Nominal damages. Where no loss is suffered by the aggrieved party, the court generally awards nominal damages. Damages for inconvenience, etc. Next point. Damages for inconvenience, etc. Where a party has suffered physical inconvenience, discomfort, or mental agony as result of breach, the court may award damages for the same. Next point. Liquidated damages and penalty. Where the parties to a contract specify a certain sum in the contract, which will become payable as a result of breach, such specified sum is called as liquidated damages or penalty. If the specified sum represents a fair and genuine pre-estimate of the damages likely to result due to breach, such specified sum is called as liquidated damages. If the specified sum is disproportionate to the damages which are likely to result as a result of breach, such specified sum is called as penalty. In India, damages shall be restricted to a reasonable compensation not exceeding the specified sum. Forfeiture of security. Deposit. If any loss is suffered by a party as a result of breach, the damages awarded to him shall be limited to the loss suffered by him. Any clause in the contract entitling the aggrieved party to forfeit the security deposit is not valid. Payment of interest. Payment of interest is permissible. If no rate of interest is mentioned in the contract, the party shall be liable to interest. A. As per any law for the time being in force. B. As per the custom or usage of trade. However, if the interest is in the nature of penalty, the court may grant relief. Next point. Suit for specific performance. Specific performance means demanding an order from the court that the Promise specified in the contract shall be carried out. When is specific performance allowed? Actual damages arising from breach are not measurable. Monetary compensation is not an adequate remedy. When is specific performance not allowed? Where damages are an adequate remedy. Where the performance of contract involves numerous or minute details, and therefore it is not possible for the court to supervise the performance of the contract. Where personal quality of a person is the subject matter of contract. Where the contract is dependent upon personal volition of the parties. Where the contract is inequitable to any of the parties. Where the contract is made by a company beyond its powers as laid down in the object clause of Memorandum of Association. Specific performance cannot be enforced against a minor. Next point. Suit for injunction. Injunction means an order of the court restraining the other party from carrying out a particular act. When is this remedy available? The court has the discretion whether or not to grant injunction. Where a party to the contract promises to do an act but refuses to perform such act resulting in breach of contract, the aggrieved party may claim an injunction order from the court restraining the defaulting party from performing such act in future. Lastly, suit for quantum merit. 1. One party preventing the other from completion of contract. If a party prevents the other party from completing his obligation under the contract, the aggrieved party may claim payment on quantum merit for the part of contact already performed by him. 2. Divisible contract partly performed. A party at fault may sue on quantum merit if the contract is divisible, the contract is partly performed, and the party not at fault has enjoyed the benefit